First District Court of Appeals now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon. Welcome to the First District Court of Appeal. We have one consolidated case on the docket. That is 20-1185/1189. It's Calder Racecourse versus SCF and DBPR. Counsel, y'all have worked out who's going to talk when? Okay, you may proceed when ready.
May it please the court, my name is Jake Wielden, and I represent the appellant, the Department of Business and Professional Regulation, Division of Pari-Mutuel Wagering. Seated with me is Kristen Fiore, who represents the appellant Calder Racecourse. Today, I plan to spend 8 minutes explaining why the administrative law judge was incorrect when he found the division relied on unadopted rules when it renewed Calder's slot machine gaming license. Ms. Fiore plans to spend 8 minutes discussing the issues of standing and the doctrines of preclusion. We would like to reserve 4 minutes for rebuttal. Your Honor, this case constitutes nothing more than an attempt to find a duplicative backdoor means to challenge the division's licensing actions. Every rule, including an unadopted rule, must be a statement. However, here, there was no actual statement, either of general applicability or otherwise, which was alleged in the petition or proven in the hearing in the case. To attempt to find such a statement, the ALJ was forced to resort to taking judicial notice after the evidentiary hearing had concluded and after the parties had already submitted their proposed recommended orders, of what he claimed to be the salient points of a licensing order in a different case. The ALJ then was required to restate what he claimed the salient points of the order were, to use these points as a faulty basis for finding alleged statements, which he classified as unadopted rules. All these actions resulted in his issuance of a final order containing incorrect conclusions of law and factual findings that weren't supported by competent substantial evidence, which serve as fatal defects to that order. First in the series of errors that the ALJ engaged in was
I'm sorry to interrupt before you get too far in. Did you say co-counsel is going to address mootness, or who is going to address mootness?
That's correct, Your Honor.
Okay.
Yes, co-counsel plans to address mootness, standing, and the other doctrines.
Okay, thank you.
Yes, that's correct. The first error that the ALJ made was a material error by admitting the licensing order after the hearing had already concluded and the parties had submitted their proposed recommended orders.
Well, on that, I mean, it was okay to consider it, but he specifically said, I'm not considering that it was an unadopted rule itself. But isn't that okay to take the department's position as stated in that case, at least as a piece of evidence?
Your Honor, had the ALJ, during the course of the hearing itself, had there been a motion by one of the parties to have the licensing order admitted into evidence, or had the ALJ, as happened here, decided sua sponte that he was going to admit the licensing order into evidence, that would have been proper. However, the case law is very clear, and this court, even in Craig v. Craig, stated that the evidence code specifically contemplates that a request for judicial notice, such as the mechanism that was used to admit the licensing order here, and taking of notice in accordance with that request by the trial court, is going to occur before or at the trial as part of the case.
But how is that any different than, you know, a panel here or a trial judge, after a hearing occurred, a new case comes down from the Supreme Court, and we rely on that case to decide something? I mean, I think there's two issues. One, whatever reliance he did, but just looking at the case itself, or in this case, the order, how is that improper?
Your Honor, the difference is that if another decision comes down, say from the Florida Supreme Court, and this court is then examining that decision, this court is examining that as legal precedent. And that's not what the ALJ did in this case. Instead, the ALJ used that as a piece of evidence, which he then derived an alleged statement from. He wasn't simply using it for a legal tenet or as part of his argument. Instead, he was trying to find evidentiary proof that he wanted to use to try and back his order in the case itself. This should be treated not as a court decision, as Your Honor implies, but instead in the same manner as any other piece of belatedly admitted evidence. And therefore, it should not be admitted in. It should never have been admitted in.
And that order was affirmed by the Fourth.
Pardon?
That order was affirmed by the Fourth District.
Your Honors, that order was affirmed by the Fourth District. There is currently a motion for rehearing en banc and a motion for written opinion because it was a per curiam affirmed. Those motions are currently pending.
Okay.
And that's the status of that case.
And I know you're not arguing standing, but if we find that standing was lacking, your other arguments become moot, or do we still need to address your other arguments?
If Your Honor believes that the basis for standing of mootness is on the recent bill, then our position is that, as we detailed in our supplemental brief, which was submitted last week, then our position is that this court would still need to hear the merits of the case because there's been a motion for a mandatory award of fees. However, if it's standing based on, as we stated in our brief, the lack of compliance with the zone of interest for the statutes or something like that, basically standing relating all the way back to the ALJ's original decision, then this court would no longer need to rule on any of the other points of the case, because what this court in effect would be saying is the ALJ should have concluded there was no standing and gone ahead and kicked the case even prior to his opinion, possibly, or that would be the only thing the ALJ would have needed to address in his opinion.
And the effect of that would be to vacate essentially, or at least prevent the recovery of fees in the court below, or the administrative form below.
Yes, Your Honor, that's our opinion in this case, is that would be the effect, because the below opinion would be basically vacated due to the lack of standing.
And if we were to dismiss it, this appeal, if we were to dismiss it, there still could be at least a pending claim for attorney's fees because they prevailed below and they haven't had an opportunity to get it affirmed or reversed.
Yes, Your Honor, if it was to be dismissed on standing, specifically if this court was to dismiss this on standing, again, based on that bill that is still has effect pending with the Washington and the Secretary up there.
Okay.
Yes, that's correct. Second, the ALJ's conclusion that the division made statements of general applicability which implemented, interpreted, or prescribed law or policy was simply incorrect. Again, here, the division made a licensing action. That licensing action did not constitute a statement, and an unadopted rule challenge, such as the challenge that was brought by SCF, should not serve as a backdoor means to get a second bite at an apple of an agency decision that they dislike.
Does the contiguous, the word contiguous, does that play some role in this? Because there is not strict contiguity here in the sense that the two structures are next to one another, touch one another.
If Your Honor is referring to whether or not the division's interpretation of contiguous was based on plain language of the statute, or whether instead it required an interpretation which exceeded the plain language and might have engaged in rulemaking, I believe that's a point of contention among the parties. The division's position has consistently been that A, what it did here was not a rule, it was a one-time licensing decision, and B, when making that decision, that it simply used the plain language of the statute and contiguous and connected in a term together. That contiguous, again, meant that it was on the same piece of property here, that they were close but not touching, again, which was satisfied by the slot machine building in this case and by Calder's live gaming facility. And that was evidenced even by the testimony that a number of individuals had, that the two were only a short distance apart. They weren't very far.
Could you have an unadopted rule even if it just applied to one license?
So it would be, it's technically possible that you could have an unadopted rule which was at the current time only applicable to one licensee. However, there is, as we saw here, there are a number of practical concerns regarding the idea that you have there. For example, the ALJ here mentioned that perhaps another licensee might choose to build a slot machine building in another place. However, there are a number of practical concerns, expense, et cetera, and there has to be a line that's drawn at some point that says even though it's hypothetically possible that another licensee could engage in this behavior, they would never engage in that manner of expense in this means. And if Your Honors are acceptable with that, I will go ahead and pass it off to my colleague.
Hi, good afternoon, Your Honors. I'm Kristen Fiore here today on behalf of Calder Racecourse, and we are going to reserve 4 minutes collectively for rebuttal. I know Jake mentioned that. So, Judge Makar, you had asked a question about mootness of the appeal, and I am not. Calder's position, as we stated in our supplemental brief, is that the issue of fees is between the division and SCF. So we do believe that is not moot based on the case law, but we don't really have a position on that.
Well, do we have to resolve the merits?
No.
Or we have discretion to resolve the merits?
Well, I believe you have discretion to solve the merits, and you also don't have to get to the merits in this case because of standing.
Right.
Which we believe.
SCF standing?
Correct. SCF standing to bring the petition in this case.
Right, not the mootness issue. It was-
Right.
I think co-counsel was saying mootness/standing, but what we're talking about is the standing in this case of
Yes.
SCF. Okay.
And it's a little complicated in this case because of all the different doctrines going around, but there's the issue of SCF's standing to bring the petition in the first instance. And our position is that they did not establish standing under the two-part test. There's no immediate injury in fact. In fact, by its own admission, I encourage you to go back and look at the testimony on pages 183 to 214 of the hearing transcript. Ms. Kitos, who is the principal of SCF, she testified that Calder's, quote, "I'm not here about Calder's slots. Calder's slots are not my interest." And Ms. Kitos also testified that SCF stated it filed the petition in this case because FTBOA, which is the
Horse Breeders Association.
Exactly. The Breeders Association chose to reduce breeders' awards. Well, then she went on to admit that Calder in no way decided, authorized, or directed that decision by FTBOA. And she also testified that SCF has not been harmed in this case, that in fact it's fared quite well, and that it benefits from the existence of the slot machine operations on Calder's property.
We could say their substantial interests are benefited versus harmed. I mean, they're being affected.
Under the substantially affected,
Right, so
correct.
it may meet
but
that, but it's not a negative, it's a positive
correct.
effect.
But, if you're talking about harm, injury, there was no injury here, and they've basically admitted it through her testimony. And then if you look at the zone of interest test, the zone of interest to be protected by the proceeding or the statute at issue here has nothing to do with thoroughbred racing. It is a slot machine license proceeding. It has nothing to do with thoroughbred racing, no matter how hard SCF might be trying to fit it into that box, for lack of a better word.
Well, there is at least some ripple effect. I mean, that's what the ALJ characterizes as in all these gaming facilities where you have multiple types of activities going on, thoroughbred racing, slot machines, so on, High I guess, and some, whatever. I mean, there's some interconnectedness, but I understand the argument to people, there's just not enough of a direct, immediate, harmful effect here.
Correct. And while there may be a ripple effect in some sense of it, there is no evidence of that in this case at all. In fact,
Doesn't there have to be some pari-mutuel activity going on for them to have a slot license, though? I mean, so isn't that a sufficient connectiveness?
there does have to be a parimutuel activity going on. However, that if you look at their claimed harm in this case, which is the reduction in their awards, there's no evidence that the removal of the grandstand, which is their main, for lack of a better word, beef in this case, had anything to do with any reduced awards. There is extensive evidence in the record that the attendance at Calder was declining prior to the removal of the grandstand, that people were not coming as much, and so there's no evidence in the record that has a causal link between the removal of the grandstand, which is basically what they want Calder to do here, is build the grandstand again, or build another building, and the decline in wagering handle, which is the alleged harm. So that is what we maintain takes it out. In addition,
It seems to me that if you have to
if you have to go through the horse racing area to get to the slots, chances are you might bet the ponies on the way. If it's in a different building, there's no synergy there.
So I can see how it may appear that way, but if you look at the record, I encourage you to look at the testimony of Calder's witness on page 521 to 524 of the hearing transcript, where he explains that there was really no, I can't recall the word he used, but no connection. He had all the data of the player cards and everything prior to the grandstand's removal. There was really no connection between the activity that was going on regarding the thoroughbred racing and the folks that would play the slots, that they were not always the same groups of folks. And that didn't change afterwards. So that maintained its consistency. So while you might think that in the record here, the evidence says otherwise. And we also asked the court to reverse based on multiple preclusive doctrines in this case.
If I could ask you a factual question. When
Yes.
does the current license expire?
Okay, so the license at issue in this case is the 2019 to 2020 license. So technically,
It's expired.
yeah, we're already in another licensing period. And so that plays into, kind of the confusion in this case about the fiscal years. They go on fiscal years.
Well, has it been renewed for the 2021,
Yes.
22?
Yes, the slot machine license, yes, sir.
Okay.
Yes, Your Honor.
Okay.
Anyway, back to the preclusive doctrines briefly, because I'm close to the rebuttal time. We believe that this case is barred by administrative finality and res judicata based on Judge ALJ Stevenson's order in the 2017
As
case.
far as the res judicata, the parties are not identical. So why, you may have an argument on collateral estoppel, but how does the res judicata apply?
Okay, so the standard for the identity of the parties, right, is either it's the same party or in privity with the party. And the case law, there's a case law, UDIC out of the 5th DCA, Stagmu out of the Florida Supreme Court that discusses a virtual representation concept. Here, there is a statute, this is a unique circumstance in which the representative relationship between FHBPA who was the petitioner in the prior case, and SCF is statutory under 551-104-10A1. This is in our brief.
But didn't SCF file some sort of form to opt out of the Thoroughbred Association?
So there was testimony that they weren't members, but we maintain that it doesn't matter because FHBPA still represented them under statute regarding the distribution of prize money at under that statute, under Chapter 551. And it's similar to this court's opinion, also another SCF case where the court remarks, even though SCF's membership in FTBOA, the Breeders Association lapsed, that didn't prevent it from the eligibility to receive awards. So it was represented in that case, and I see that we're into our rebuttal time. So.
Okay, since that was based on questions, I will give you an extra minute to bring
Okay.
you back up to 4.
Okay,
And
thank you.
Mr. Romanek, you will get an extra minute if you choose to use it.
Thank you, Your Honor. May it please the Court, David Romanek for SCF. First of all, this is not a licensing case. This is an unadopted rule case, and the challenge here is to the policy of waiving statutory requirements for licensure. And to me, it's no different than the barrel racing case that unfortunately I was involved in the losing side of, and I raised a lot of the same arguments here, that licensing is between the agency and the licensee, and no one else has any interest in it. And that argument was rejected, and it was also rejected, Judge Makar, in the opinion you wrote the first SCF case, because they argued the same thing there. This is only between the agency and the licensee and the applicant, and has nothing to do with any of the people that might be affected by the issuance of that license. And with regard to this trickle-down effect, there was evidence in the record that after the grandstand was demolished, live handle dropped 60%. That's an injury. That's damage. And even though it's already been knocked down at Calder, The whole purpose of this was to prevent Gulfstream from doing the same exact thing, because after the division sanctioned this at Calder, what would keep Gulfstream, which is the only thoroughbred track left down in South Florida, from doing the same thing, knocking down its grandstand, having a standalone casino, which surely is not authorized under the literal language of 551-1144, and then the Horsemen would be in the same exact place they are now at Calder, with a low-end racing facility, which is contrary in SCF's opinion, and in the opinion of the witness Dave Roberts, who was the division director back in 2005, of the purpose of adding into the parimutuel statute protections for the live racing industry. So this exact thing did not happen to them. And this was the fear of all horsemen going into slots in the first place, because if you had a choice between slots and thoroughbreds, everyone would take slots. I mean, it's a no-brainer. So the purpose of adding in the requirement that the parimutuels conduct a full schedule of live racing, which is not a requirement for a card room, and it's not a requirement to get a parimutuel license, but it is a requirement if you want to run slot machines. There's a requirement that the revenue from the slot machines be shared with the horsemen in the form of purses and breeders' awards. There's no similar provision over in 550 because slot machines aren't mentioned there. There's a requirement in the statute that the track remain in compliance with all the provisions of 550. I mean, there are a number of these provisions that went in as protection for the live racing product, so it wouldn't be disfavored in favor of slots. And here,
Pardon me, I should know this, but you can tell me. What evidence in the record is there of your client's negative impact from what's happened? In other words, I assume your client breeds horses, has them at these races. Have they had fewer awards made? Have they not been able to race as much? And what evidence is in the record that were findings of fact by the ALJ?
well, Your Honor, the way that racing is done these days is you have the live on-track handle, which happens at the place where the event is happening live. And then you have all forms of remote gambling, the inter-track wagering, where other tracks in Florida can take the races at Calder and bet on it, or at Gulfstream or any of the tracks. And also there's something called advanced deposit wagering, which is basically internet gambling. So anyone with a computer or a television, really, they can watch all the races on TV without going to the track. But the greatest amount of contribution to the purses and awards, which is all statutory and it's all based on handle, the greatest amount comes from the live wager placed at the track. So when Calder, after they entered into that agreement with Gulfstream to manage their race meet, Calder, they were not benefiting anymore from any of the live wagering, so they didn't care what happened, and they went about completely discouraging anyone to come to the track by knocking down the building and just saying, here's the apron, here, stand on the apron. You can't see a race from the apron. It's impossible.
But what about my question? I mean, what
Okay,
about your client?
All right, okay, so to that point, the handle, overall handle, once Gulfstream took over management, increased. But the on-track handle decreased by 60%. So Calder's trying to take advantage of the fact that they now gave management to an entity that had broad distribution of their signal all over the world, and they were able to create this wagering that benefited the horsemen that were racing there. But that didn't take away from the fact that there's still a 60% decline on what happened on track. And if the building was still there and Gulfstream had taken over the management, then that 60%, our view is it would have come back, in addition to all the other benefits that the horsemen received by Gulfstream's superior management and superior distribution of its signal coming into the fold.
Well, what I'm getting at is, in the case where you represented your client about some formula, I forgot exactly what it was, about how the money is divided up, you had shown in that case that your client had horses that had placed regularly, and therefore it was predictable, highly likely, that they would have future awards because they'd had past awards. So therefore your client had standing because they could show a direct impact from that allocation formula on them. And I'm trying to figure out, in this case, where that
Well,
direct impact is.
There was evidence in the record of all the horses that were raced at Calder during the period after demolition by SCF. I mean, it's in the record. And it shows what horses, when they ran and what they earned. My point and the point of the case is that that amount would have been higher by the 60% of the on-track handle that was lost because of the subversion of the statutory scheme and allowing the building to be knocked
But
down.
it sounds like a balloon to me. It looks like the balloon got squeezed on the one side, the stands aren't there anymore, but the balloon got bigger over here. No? That's not what's going on?
Well, Judge, I think it's impossible for anyone to say that those people that didn't come to Calder went over and bet somewhere else. I mean, it's total speculation as to why there was an increase in overall handle. All we know for sure is it was a 60% decline in on-track handle because the building was knocked down, and this statute, the literal words of it require that there be a live gaming facility at the property. And the fact that there wasn't caused there to be a 60% decline in handle on track.
But as far as the injury, though, that SCF had to suffer to have standing, you know, the two-part test, how do you respond to Calder Counsel's discussion with regard to Ms. Kiddos and her testimony that there wasn't, you know, apparently any injury to SCF?
Well, I think that the evidence showed that the overall handle under Gulfstream's management went up. Purses and Breeders' Awards are based on handle. It's a direct correlation between the two. The higher the handle, the higher the purses. So because of Gulfstream's management, overall handle went up. But that component of the handle that this statute is directed at went down by 60%. That's where the injury occurred, because if that handle was where if the building was there and the handle at least stayed at the same level that it was, the purses would have been that much higher. So it's the fact that the on-track handle decreased by 60%, which is exactly what this statute is directed at. That's where the injury comes from. All of the testimony that overall it was, you know, it went up, that would have happened anyway because of the change in management, but they couldn't identify that it went up at Dania Highline or went up at Gulfstream or went up any place that they say those people would have come to Calder, but they didn't. There was no testimony as to where the increase came from. Was it ADW wagers taken in China? I mean, no one, that part of it was never addressed by them because there was no way they could have known it. The only handle figures in this that anyone can determine concretely that were affected by the demolition of the grandstand was the on-track handle that dropped 60%. But in addition, though, just to the, you know, to the dollars and cents, there's another case, Bluefield Ranch, which is a 4th District Court decision that says that participants in an industry have a substantial interest in the enforcement of compliance with the statutory requirements for that industry. There was a wetlands mitigation issue, and when a participant claimed that DOT and the South Florida Water Management District had subverted the applicable statutory scheme. That's what I'm saying here. It's the same thing. They violated the statutory scheme by allowing this facility not to have a grandstand, which resulted in a 60% decline in the handle.
Well, the fact of the grandstand, that goes to the merits, and you've got to have facility, and it's got to be what, contiguous and attached.
And connected, right.
So why is the apron and the tiki huts and the tents not a facility?
Well, in 2005, when the statute was enacted, every parimutuel facility in Florida had a large grandstand building.
Well, I agree with you that it's, you know, apparently not as nice a facility, but the statute doesn't say a facility enclosed and air-conditioned of, you know, 100,000 square feet or something like that.
I agree.
Just facility.
I completely agree. But facility is defined as a structure designed for a particular purpose. A structure. There's no structure there. Now, I know that they pointed to the definitions of parimutuel facility, which is a defined term, and eligible facility, which is a defined term in the statute. But live gaming facility is not a defined term, which then requires the court to apply a plain meaning analysis to it, which is dictionary definitions. So the dictionary definition of facility is a building. It's not some vacant piece of tarmac.
Well, that's
So-
one definition. I mean, I guarantee you there's more than one definition of facility in a dictionary.
An airfield would be a facility, right? I mean,
Yeah, and maybe if there was a statutory definition that said an airfield just as a piece of tarmac, that'd be one thing. But are there airports that don't have, control towers, terminals, places to store the planes? I mean, to me, again, the legislature could have defined it easily if they wanted to have a standalone slot machine building, they could have defined live gaming facility that way. They had a lot of options here. But
as far as contiguous, would you agree that the statutory definition is a little broader than normally when I think of contiguous, you would think side by side or abutting.
Touching,
But it
right.
seems like the statutory definition of contiguous is a little bit different. I had it written down somewhere.
Oh, I know, but Your Honor, it's not in the same statute, and it's in Chapter 550, and they defined it, and they said for the purposes of this section, contiguous means this. So it goes back to that whole line of cases that say that unless expressly defined in the statute, you look to the dictionary for the meaning of the term. And the meaning of the term contiguous, there's a third district court decision that I cited, is touching. So, and then, so how they can reach over and say, well, in another statute, that this defined term means this, and therefore in this statute where it's not defined, it means the same thing as the defined term, that doesn't wash under the case law.
Well, I mean, they've taken it from a parimutuel statute. They didn't take it from some environmental or something totally
Right.
out of left field.
Well, what that other statute did was allow for an exemption from the zoning requirements for buildings that were built on basically on the racetrack. And they defined contiguous to the racetrack to be either within the racetrack or adjoining the boundary of the racetrack. It has nothing to do with this particular type of contiguous, but if you look at it, one says contiguous and the other one says contiguous and connected. So you have two requirements. But if in fact they intended that definition to apply, then why didn't they say contiguous is defined in this section? Or why didn't they define contiguous to mean what they intended rather than not defining it, which then throws it back into the regular definition of contiguous based on the dictionary, which is touching? I tried to run through all these rules of statutory construction just to show that it's not readily apparent from the statute that you engraft into this statute definitions in other statutes. I just don't think the case law allows that to happen. And when you're looking at this, it has to be easy to see. And how is it easy to see from this statute that now you're referring over to this other statute in another section, another chapter of the laws? I don't see how that's readily apparent. Readily apparent means easy to see from the literal language. And I don't think you would know, looking at contiguous and connected, they intended that it would be contiguous as defined in Chapter 550.
Did you have the opportunity to amend your petition after the order was entered in the Florida Horse Breeders Association case?
No, because
Okay.
the trial was already over and that came after the fact.
Okay, so the division's final order in that case, that the ALJ, Van Lanningham, asked the parties, that you're saying that occurred when the pleadings were closed and the case was already been submitted?
Well, see, what happened in the other case, that case was tried, and then there was an appeal, an interlocutory appeal, and that was pending for 6 months before it was dismissed, and then, the rest of that stuff happened in that case. But this case was tried September 11th and September 23rd of 2020, while that other case was still pending here. a non-final appeal. So then, when the final order was entered, the trial had already been over, and we had already submitted our proposed final.
Okay,
And I-
so
and I
it truly
think-
was the trial, it was truly the trial, the ALJ here, who was the impetus behind essentially taking notice of this order.
Right, well, if you look in the transcript here, the two division employees they never really gave a definition. They didn't explain their policy. So when that order came out, it expressly said, this is the division's policy, that a standalone casino is okay under this statute, and that an open-air environment is okay, even though, these slot machines are supposed to be within the live gaming facility, and how you can have slot machines out in the middle of a tarmac with the electricity and all the stuff needed and the overhead surveillance. I mean, where does that come from? A satellite? I mean, it's just, everything here is just so at odds with what the language of 551.114 says.
Well, going back to that order, it was the same ALJ, right?
Right.
Whose order was critiqued and changed by the division that became the final order in that case.
Mm-hmm.
So he wanted, basically, it sounded like he wanted to use that and say, wait a minute, this is their position, this is how they view things, according to under the unadopted rule analysis.
Well, that's because what they said in the order was different than what the testimony was. And he was trying to reconcile it, so he actually had a statement, because he couldn't get a statement out of Director Trombetta or Deputy Director Dillmore. He couldn't get them to say what the reasoning was behind their policy. So when they put it in writing, he said, okay, now I know what their policy is. They've now said it in
Did he
writing.
beat you to the punch? In other words, why didn't you take action when that order came out? In other words, I mean, there's this order that the ALJ used in this case to your benefit. Why didn't you present that to the ALJ in the first instance to try to advance the cause in your case? Supplemental authority or judicial notice?
I'm not sure I understand the question.
Well, what I'm trying to get at is why didn't, I mean, that order was used by the ALJ, and he entered a final order that's on appeal here that benefits you and your client, correct?
No, that final order actually reversed the recommended order of Judge Van Lanningham when he said it was not contiguous and connected, and they weren't entitled to the license. Then the division overruled him on what I think is an issue of ultimate fact, even though we won't know because the Fourth DCA didn't say why they did what they did.
I may be confused, but I thought that the purpose of the ALJ using that division's order, division final order, was as a piece of evidence to show that there was an unadopted rule.
I think he used it because that was the first time that he could get the agency to actually describe what their policy was. So he didn't want, I don't think he wanted to misstate their policy. He wanted to use the policy that they said, this is our policy. And I think that's why he did it. I was really surprised that they objected to it because all it did was reiterate exactly what they ruled in the other case. And since, the cases aren't the same, but the issues are related in a way. And I think he was I think he was trying to be fair to them, saying, okay, I don't want to assume what your policy is. You've now said it, and I'm going to use what you say the policy is, and judge the readily apparent standard to what you say the policy is with regard to the statute.
Wasn't it Calder's facility at issue in that case?
Yeah, it was.
The same thing we're talking about today.
But
right?
again, I know this
Am
is.
I right? I just I don't want to be mistaken. Are they the same?
Well,
No?
again, I don't view this as being about Calder. I view
Well, I'm
this.
just trying to get the facts straight. I don't want to be confused about it. I'm trying to get you to help me.
Okay. It was Calder was in the 12057 case that was just decided by the Fourth. Yeah. Grant that same exact policy to everybody else who would apply. And it was Gulfstream that the horsemen were in fear, or SCF was in fear, was going to do the same thing. And then if Gulfstream's on-track handle went down by 60%, there'd be no horse racing industry in Florida anymore. So again, all this is about preserving the protections that the legislature put into the statute in 2005 and preserving them, which in our opinion, once those protections were breached, it resulted in a 60% decline in on-track handle. So I guess my time is up here.
Your Honors, briefly, I just want to discuss a few things that were discussed in that argument. First of all, to the extent we're talking about the SCF case that this court issued a few years ago, that case is different. That case came up under Chapter 550, the parimutuel statute. This case is about Chapter 551. To your question, I believe it was Judge Makar about the negative, is there any evidence in the record of a negative impact to SCF? The answer is no. There is no evidence in the record that that links the removal of the grandstand with any sort of negative impact on SCF. To the extent we're discussing the 60%, et cetera, there's no link between that 60% and the removal of the grandstand. And to the extent SCF maintains it, quote, would have been higher, that's completely speculative. And as we know from the standing case law, you cannot base standing on speculative things or conjecture. In addition, it's not, SCF mentioned the industry. No, we're not talking in this case about the thoroughbred industry. We are talking about the slot machine statute and what is required and permissible under that statute. Regarding the definition of facility, just very briefly, I'd encourage the court, as we cited in our brief, to refer back to the 2019 FTBOA case in which this court addressed the definition of eligible facility and declined, says defining facility too narrowly would not allow the slot machines to be located in connected buildings or anywhere on the premises that is not within the footprint of the actual racetrack or fronton. It's inconsistent regarding the contiguous, asking not to look at the contiguous, the definition of contiguous in Chapter 550, which does inform the question here. It's inconsistent for them to say that we can't look at Chapter 550 for definitions of a term, but Chapter 550 is what governs the thoroughbred racing industry that they want to proceed under here. In addition,
Quick question.
Yes.
If we were to affirm, what would be the result? Meaning, would there have to be a grandstands be built again, or what?
I missed the first part, but you said if we affirm, if you affirm.
If it's an unadopted rule, what's the remedy?
So the remedy is that the division engages in rulemaking, contingent on whatever happens in Washington regarding this amendment. And no, the remedy is not to strong-arm Calder into building a grandstand. That's not the remedy here. The remedy here has the potential to really harm SCF because they'll be losing out on revenues from the slot machine operations.
But is the remedy that they have a piece of paper that says we won, we get our fees, and life goes on, or is there really some impact?
So
on
I
the
think,
facility?
because the fee claim is ours, I'm not entirely sure how that works, but I believe that there would potentially, and I don't want to speak for my counterparts, maybe have to be some additional briefing depending on what happens with the amendment in Washington on whether or not the merits of this dispute entitle them to fees under the.
But on the ground, at the facility, things go on as they currently are.
I'm sorry?
Things continue as they are now at the
Yes.
facility?
Yes, Your Honor.
Regardless?
They continue as they are today.
Okay.
Correct. And if there are no further questions, we'd ask the court to reverse the final order on standing and the preclusive doctrines, or at a minimum on the merits. Thank you.
All right, counsel, thank you for your arguments. We have no other cases today, so we are adjourned.
All rise.